The topic that we are discussing right now is proprietary versus personal interests. Now, proprietary, basically simply put, means land interest. Now, there are two types of interest in land. One is, I just mentioned, proprietary interest that may or may not be registrable. Now, meaning you may not be able to put your name in the title, but it is nonetheless an interest in land. It can be protected by a caveat. Now, today we will not talk so deep into caveat, but caveat definitely will deserve another video. So I have another video on caveat coming up. But this video itself, I just want to make the distinction between proprietary and personal interest. Now, of course, personal interests are definitely not registrable and not caveatable. Let's start with proprietary interest in land. For example, of course, you are the owner of the land, so that's called land ownership. Or maybe you will be the future owner. So now, these are called interest in land, proprietary interest. But then later on, we will discuss whether or not, if you have a future interest, can you register your name in the title? Okay, so now let me finish this example. Land ownership, future ownership, claim to sale proceeds. Now, of course, the bank will then make a claim to the sale proceed. Of course, if you are using your CPF savings to invest in the property, of course, CPF board will also want to claim the proceed. So meaning the bank will have a proprietary interest in your property, meaning the bank has a land right over you. Now, so I just want to further explain. A proprietary interest can also exist in two forms, meaning it can exist in the form of a legal interest. It can also exist in the form of an equitable interest. Now, example of legal interest, which I just mentioned, legal ownership, legal mortgage, maybe even legal right of way, which is called easement. Now, what about equitable interest? Equitable ownership, for example, maybe you have just paid for an option to purchase a property. Now, an option to purchase will give rise to an equitable interest, meaning you're just an equitable owner, you're not the legal owner yet. So what you can do to protect your interest is that you can lodge a caveat against the seller. Equitable mortgage. Say, for example, you just bought a property under construction. Now, your name is still not in the title yet, but you have already approached the bank for a loan. So now, the bank can only protect its interest using a caveat. And the bank cannot register its interest into the title. Because why? Because in the title, you are not the owner. And also, in the old days, there were many gentleman agreement made over land. I will make other videos to talk about this gentleman agreement, example of which is restrictive covenant. For example, in the past, you always have bungalow owners promising each other that they will not subdivide their land. And if they register the promise in a deed and then register it with SLA, now that will become legal interest. But many of them are just keeping the promises as gentleman promise. So these are called equitable interest. So like I mentioned, I will have other videos explaining this one. Now, I just mentioned registration means put your name into the title certificate. Of course, the most obvious example will be ownership. You register your ownership. But other proprietary interests can also be registered into the title. Now, they may or may not be the owner. So one's proprietary rights, means rights over the land, can be written into the title. Example will be legal mortgage and right of way. When you do a title search, then you will see even government departments, they can register their rights into the title. So when is a proprietary interest registrable? The first example, very clear, legal ownership upon legal completion, meaning the new owner will find his name in the new title. Legal mortgages, of course, you can only mortgage to one bank. So on the day you become the legal owner, the bank also become the legal mortgagee. So now in some other lectures, I talk about long leases. Now once you have a long leases, that means you have a leasehold interest. Now you also register your interest. Now that's proprietary interest because you are the owner for that specific period of time. Registration of a deed that give rise to legal easement, restrictive covenant, even a trust. Now, when is a proprietary interest in land not registrable? Equitable ownership. Now, earlier I mentioned when you have paid for an option to purchase, you have become an equitable owner. You are not the legal owner yet. So what do? You can't register your name into the title, but you can lodge a caveat against the seller to make sure that the seller cannot grant another option to another buyer. Now, you are a beneficiary of a will or a trust. Now, you are not the legal owner yet. So now some of the trust, the beneficiary will never become the owner one. Okay, so like for example, you're put under a guardianship, which is a form of trust, and wait until you're 21 years old. So in the interim, you can protect your proprietary interest by way of a caveat. Will, I don't think so. Now, tenancy not exceeding 7 years, of course, non-registrable, non-caveatable. Remainder of a life estate is very similar. You can also lodge a caveat because you are the future owner. So liens, now liens will be an interest that that may or may not involve money. So later on, I will talk about builder's lien. Now, there are 3 types of liens. Purchaser's lien. Now, say for example, if you look at the equitable ownership, the first point, equitable ownership. Now, once I have paid for an option, now I will have the purchaser's lien, meaning I have interest, equitable interest in the property already. So now in the bull run, you'll always find that the seller will regret, and we call it seller's remorse. So they will find some excuse to try to get out of the contract. So then the buyer will sue. The buyer will sue based on the strength of a purchaser's lien. So of course, while suing, the buyer will also lodge a caveat against the seller. Now you have purchaser's lien, which I just mentioned. Then you have vendor's lien. There's the seller's lien. Now vendor's lien basically is to protect the seller for or over his full purchase price. Full purchase price. So I will make another video to explain lien, but later on I will talk about builder's lien. That means now if I help you to build the house and after that you don't pay me, now you owe me the construction cost. So I can lodge a caveat against you. So okay, equitable mortgage will be before I become legal owner, I already got the bank to lend me the money. So that is called equitable mortgage. Now, there will also be land interest or land right that is non-registrable as well as non-caveatable. Okay, caveat is a notification, meaning before you are able to register, you may be able to notify the land office that, hey, I have an interest. Now, interest must be proprietary in nature before you can lodge a caveat, meaning the earlier slides I have explained what are proprietary rights. Okay, for example, a equitable mortgage that is proprietary in nature, but then not yet a legal mortgage, but in the interim, it is just an equitable mortgage. So now the interest is over the land. So therefore, the bank can lodge caveat. Okay. Now, so there will be interest that are allowed under Singapore law for caveat to be lodged. Example will be the state, meaning the Singapore Land Authority, can lodge caveat against foreigners who own land illegally. Now they'll be asked to sell the land, and then the government will actually lodge a caveat to actually garnish the sale proceed, just in case there are fines to be paid. Now, management corporation has the positive covenant to actually enforce the payment of maintenance fee. Now, but paying maintenance fee is not a proprietary interest. So it's just a personal promise that I will pay you. But then, because the situation has gotten worse, so last year, the government has actually passed a law, in fact, it's under BCA, allowing MC to lodge caveat against unpaid maintenance fee. Now, non-proprietary in nature, meaning you have personal rights that are not land rights. That means things like license, even a long license, a temporary occupation license. Example, work site office, work site canteen, Formula One night race, you can see the spectators stand. They're actually erected on public roads and some public land. So those are called temporary occupation license. Like for F1 night race, it happens just once a year. So those are called license. So when the event organizer, when they start to build the staging and all that, they cannot lodge caveat because these are just personal interest, temporary interest. Now, right of first refusal is often written into the contract. For example, you have a tenancy where the tenant say that landlord, if you want to sell your shop, your property, then you have to offer to me first. Or if somebody give you an offer, you must bring the offer to me first to see whether I want to accept. So that's called right of first refusal. Now, those are non-proprietary in nature. Now, in the earlier slides, I talked about paying maintenance fee. Those are positive covenant. Now, they are made enforceable, and it binds subsequent parties, such as when you sell your house to another person. So another person is also bound by the covenant to pay maintenance fees. Now, only if this kind of payment fulfill the mutual benefits and burden doctrine, meaning you have to pay for the maintenance of these facilities. Now, you are a resident in this condo and you use the facilities. So therefore, when you use the facility, you have to pay the maintenance fee. So this is called mutual benefit and mutual burden doctrine. Principle, doctrine means principle. Now, common law debt is non-proprietary in nature, so you cannot register, you cannot lodge caveat. Unfortunately, Agents Service Commission falls under common law debt. If let's say your customers owe you commission, you can't lodge caveat, you can't register your interest into the title. Non-caveatable interest, all personal interests in land are non-caveatable. You already heard that just now, licenses and all that. Now, exception, of course, will be debts owed to MC and builder's lien. Builder's lien. Now, that is equitable for builder's cost and construction costs. Say, for example, a bungalow owner actually engage a builder to build the bungalow. Then after that, when the house is completed or maybe near completion, the bungalow owner go bankrupt. So now the bank will take over the bungalow. Now the builder got to quickly lodge a caveat to protect its construction costs. So that is called builder's lien. That means builders unpaid costs. So now that is equitable in nature. That means equitable means to be fair and just. So therefore, the law allows the construction firm to lodge caveat for construction costs owing to the builder. Now, I hope you enjoy the explanation. Now, related topic that I have also made into short videos. You have caveat versus registration, equitable interest in land, tenancies and leases, easements and covenants, since I mentioned it just now. So now, I really look forward to seeing you again. Thank you very much.